leave you on speaker. Okay. That's Donna.
Okay, okay, if everyone can just mute themselves until we get started, because we're getting some feedback here. All right, the meeting of the Public Defender Service Corporation Board of Trustees now. If everyone can just mute themselves until we get started, because we're getting some feedback here. That live streaming is not working, JT. Service Corporation Board of Trustees. Now, if everyone can just, JT, you need to mute that part of that live streaming because it's caught a delayed feedback.
Yes, we should be good, Your Honor.
Okay.
I got it.
Okay, so the meeting will be called to order. We're live streaming our Board of Trustees meeting, and we're also recording this. I'm going to ask if everyone, if you could just mute your microphone until such time as you are asked to speak or you wish to speak. And that way we don't speak over each other, and we can hear and communicate with each other. So at this time, I am going to ask the recording secretary to please call the roll.
Chief Justice Philip Carbolito.
I am present, and I am connecting to our Zoom virtual format from my chambers at the Guam Judicial Center.
Presiding Judge Alberto C. Lamarana.
PJ, you're muted, PJ.
I am present, and I am at the Guam Judicial Center.
Trustee Cynthia V. Ikubi.
Present and located here in my office in Hagåtña, Guam.
Trustee Donna Muña Kanata.
I'm present and I'm here at my office at East Hagåtña.
Guam Bar President Jackie Terlahi.
Present and from Hagåtña, Guam.
All right, we do have a quorum, and I'll ask the board members if you could just leave all your video on, because we are being recorded and live streamed, and the staff members who are participating. But at the appropriate time, if you wish to mute yourself, please go ahead and do so. There's been proof of due notice of the meeting, and at this time I will call for the approval of the minutes of the regularly scheduled meeting of June 23rd, 2020. Is there a motion to adopt the minutes?
Motion.
It's been moved by board member Donna Muña Kanata.
And I second it.
I'll second.
And seconded by PJ. And so any discussion on the minutes? There being none. All those in favor of adopting the minutes subject to corrections, please say aye.
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 Any opposition?
Aye.
There being no opposition, the minutes are unanimously adopted. And the first item on the agenda is under old business, and this is the financial status update from the PD, APD, and regarding the allotment releases. And I will recognize the financial controller, Mr. Mike Moreno. Is Mike in the room?
Yes, I am. Thank you, Yuan. Reporting for the Public Defender Service Corporation, based on what we have invoiced or requested for release of allotments from the OA as of July, we have received an excess of what we have invoiced. So at this point in time, we are at 102%.
Well, that's very good news. We've not heard anything like, I have not heard anything like that for the judiciary, so that's great.
Yes, this is my first also at PDSC.
Okay.
For the domestic violence program, Funding from the Stop 17 will be exhausted by August 31st, 2020. Funding through Stop 18 is still a work in progress. This funding, if approved, will enable the continuation of the STOP program until December 31st, 2020. And I believe we will be receiving an approval shortly. We will be contacting the governor's office for the memo. For the alternate public defender, we have just issued and submitted the fourth quarter allotment request this month on July 2nd. And for the quarter ending June, we are at 100%. And that is all for the reports and finances.
All right. Does anyone have any question for Mr. Moreno regarding the financial reports? All right, there being none, thank you, Mr. Moreno, and we'll move to the next item on the agenda under old business, and that's a report from the Public Defender Service Corporation Executive Director, Mr. Hattori. You are recognized on an update on our remote hearings.
Good afternoon, Chief Justice, members of the board. So we're actively procuring a Wi-Fi router that will enable us to create like a Wi-Fi hotspot that should reach the entire parking lot of where our building and APD's located. So we understand that a lot of our clients are actually able to Zoom from home, which is kind of surprising. They seem to have smartphones, but they don't have data plans. So they need access to Wi-Fi to be able to make the Zoom hearings at court. And so, you know, we're going to make that available to them. They could come to our parking lot and Zoom in from our parking lot. But a lot of them are actually doing it from home or from work or from wherever they're at if they have the internet connectivity. So I think we're working really well with the trial court. It seems like we are moving cases along. We've disseminated hearing waivers of physical appearance. So there are change of pleas going on, and we are moving ahead. And so if you have any questions about that, that's pretty much the extent of what we're working on. I think, I don't know, JT might be able to explain how long it'll take to get the, it's an outdoor Wi-Fi antenna, so we're having to procure that from off island. We're also trying to seek reimbursement from FEMA. We didn't get anything under CARES Act or the Burns JAG grant, although we did apply, and it was kind of interesting. We were invited to participate in a webinar for public defenders nationwide to explain, that yes, public defenders are eligible for Burns JAG grant funding and the procedures that we could use to try to tap into that. And then we also are now exploring, of course, FEMA reimbursement. I think total we probably got about $1,000 worth of PPEs from BSP. I don't know if that was under the CARES Act or the Burns JAG grant, but we're trying to really get reimbursed for video conferencing. We would love to be able to send up video terminals for our clients at each of the facilities that are the confined facilities. We've actually sent out a tablet with MiFi, and that actually worked from the Manilao facility. So we're hoping to start seeing our clients through video conferencing. We just have to iron out some issues with the Department of Corrections.
All right, thank you for that, Mr. Hattori, and I appreciate you continuing your efforts to be able to do the business of the public defender using the virtual format when that is an avenue that you're able to utilize. PJ, do you have any questions for our Mr. Hattori, our Executive Director?
No, I do not.
Okay. Does anyone else? Does anyone have any questions? If not, we will ask our managing attorney for APD, Ms. Annie Gell, if you could just give us any update in reference to your operation.
Sure, Your Honor. Same with APD. We have been able to do remote hearings either via video conferencing through Zoom or through teleconferencing on the telephone. We have been able to get a list of all the numbers that the courts, each judge has. So for teleconferencing, it's been pretty easy to give those numbers to our clients to call in. And we've had some luck, it's not 100%, but we have been able to have clients call in. We have been able to do Zoom from our office. We have our clients come in, so we do Skype with them in the office. I do have a couple of, we have done a couple of changes of plea while the clients are in custody, and we have them sign the waiver of appearance. The one I did in front of Judge Barcinas was a misdemeanor, so that was that. But it's a work in progress. We're working with your court managers, Your Honor, Danielle Rossetti, as well as anybody else we can ask for help to accomplish the mission that we have. So it's, again, everything is a work in progress, but we're getting there.
Thank you, Attorney Gell. I also appreciate your efforts, and we are all utilizing our best efforts to try and conduct as much of our business using the virtual format in terms of the Zoom tools that we have invested in reference to the judiciary. And I appreciate the support of PD and APD and trying to similarly conduct the business this way to the extent that we can. Any questions from any of our board members for Ms. Gale? So if there are no questions in relations to their update on the remote hearings, I'd like, with the if there's no objection on the part of the board, to skip the performance evaluations under the old business, because we have certain discussions in executive session relating to the performance evaluations, and we will go back to the open discussion part should there be any vote that would need to be made on the open discussion and on the open part of our meeting. So if there are no objection, I'd like to go down to our public health legal assistance seniors program. And first, I'd like to recognize Mr. Art San Agustin, the Acting Director of Department of Public Health and Social Services. Congratulations, Art, and thank you very much for joining us in our meeting. I know you are a very busy man these days, but I'm hoping that I was hoping that you would join us in our meeting so you can see closure for a project that I know is dear to your heart. And so with that, I'd just like, if there's no objection on the part of the board, if we can allow Mr. San Agustin to say a few comments before we go into our discussion in reference to the elderly law program. Mr. San Agustin.
Well, thank you so much. Excuse me, Chief Justice, Presiding Judge, Board of Trustee members, you, Chief Justice, for the congratulatory. It is a very busy job, but thank you. You know, with regards to the senior services, I'm really looking to partner with Public Defender Service Corp. I just really have this great sense that it would be a wonderful partnership. It'd be beneficial not just for the seniors, but also for the relationship. Many years have gone by, and this program would be put out for an RFP. And there's always this transition period. And, excuse me, I'm sorry. And I really want to get away from a transition period, especially when it comes to legal services for the seniors. We want to be able to provide a elder justice center, a hub that is ongoing, consistent, can be called upon 24 throughout the year, rather, not 24/7, I apologize, but it's just a place for seniors, their families, their caregivers, whether they're on Guam or they're thinking of relocating back to Guam, that they can call Public Defender Service Corp and know that there's this program for the seniors. We're talking about seniors who are in greatest social economic need. We're not talking about seniors who have the assets that could afford a private attorney. We're talking about seniors that really, if we don't provide them the service, there's a really strong possibility that they'll never see the room of an attorney and they have life matters that need to be resolved. It could be perhaps a home that they just want to make sure that they give this to a son or a child, but not in a time where they would be removed because the son is married and the wife and the mother don't get along. So we can put these safeguards. We also really want to work with public defenders so that we can provide more educational opportunities for the seniors at the senior centers, caregivers, where we could go out and provide like law clinics like the current Guam Bar Association is doing, and just really carry on that work. And so we could do weekend legal clinics for seniors, and we're looking at cases that would help them just put their life in order and really give them a peace of mind as they retire and they know everything that they need to deal with is already settled, and it's not something that is pending and they feel sad and they feel unresolved because they don't have any options and they don't believe they do. But I think our partnership would be beneficial to have and be a part of Guam's first Elder Justice Center, where we could, as partners, look at what legislation is being put forth that would affect the seniors with regards to any legal aspects, that we could provide education, training opportunities, clinics, and just really more of an outreach as much as providing legal services, but also provide some outreach activities that could help the general public for seniors. And perhaps we can even one day look at how we can help those that are nearing the age of being a senior citizen on Guam, so they can also prepare. And really just to say this to all the board members, if you would consider the pilot, let us give a chance to provide the service in a pilot status so that we can work on the kinks and so we can provide services to seniors who are in greatest social economic need. And I hope that we'll be able to do that. I hope that we'll be able to provide these legal services and educational opportunities as partners. Thank you very much, Chief Justice, Presiding Judge, and members of the Board of Trustees.
Thank you, Mr. San Agustin, and for that background information. And so before we entertain the first resolution that will allow us to engage in a discussion of the senior elderly law program, does anyone have any questions first for Mr. San Agustin, just in reference to the comments that he has made? All right. If there are none, and if you have time, Mr. San Agustin, I'd like to ask if you could just stay on, and so that if there are specific questions in reference to the discussion of the mechanisms that we are going to be discussing, it would be very much appreciated.
I will remain. Thank you so much, Chief Justice. Yes.
All right. Thank you. So the first act that we need to engage in to allow us to entertain the resolution authorizing the elderly law program is for us to modify the moratorium relating to civil cases. And Mr. Morrison has prepared for the board's review and consideration resolution number 05-20. You all have a copy of the resolution. And JT, if you could pull that resolution up, go to that part of the agenda. It's on page 26 of the agenda materials. I see you. So you need to actually it's the page number of the agenda materials. And while he's pulling that up, basically the resolve clause is that, and he is pulling that up at this time. And if you have the various recitals that provides some history relating to the moratorium that is in place with Resolution 13-12. And basically, if you can go to the next page of this resolution, you can scroll down, JT. And yeah, that's good. And so the first resolve clause, is that the moratorium involving civil and domestic cases imposed by Resolution 13-12 is hereby modified to enable the Public Defender Service Corporation to accept qualified clients in civil matters limited to the terms of the LAS program administered by Department of Public Health and Social Services, and that the engagement will be for a pilot period of 6 months and subject to it being revisited upon the expiration of the 6-month period. And so the first act is I would like to I would entertain a motion to adopt for discussion purposes Resolution 05-20, and which will modify the moratorium to allow for the elderly law program. Is there a motion to adopt this resolution for discussion?
I move to adopt for this resolution for discussion purposes.
All right.
And second it.
Been moved by the PJ and seconded by Ms. Kanata. All right, so now it's open to the floor if anyone wishes to make any comments in reference to the motion to adopt.
Mr. Chairman, may I make a comment?
Yes, please, PJ.
Okay, I'm not against the public defender accepting the responsibility for the senior citizens representation program with the Department of Public Health and Social Services. What I'm concerned is, I've always stood, ever since I sat on the board of trustees, I've always been concerned about the conflicts of interest. This will arise if the board, public defender, accepts cases aside from non-criminal matters. We've seen a history of that happening, especially in the early years when public defender represented non-criminal cases, and that created a plethora of conflicts of cases in criminal cases that subsequently arose. That's why we created different entities to take over these conflicts that public defender happened to have because of these actions. So I'm really concerned about the conflicts. So I think one of the first things we have to make sure is that public defender's first mandate is to represent indigent criminal defendants. And I think that was the original mandate for public defender here on Guam and all public defenders offices in the United States. So we have to find a way to maybe have an administrative rule promulgated by Steve and the next hearing to make sure that there are no conflicts that may arise in which public defender will have to conflict themselves out of criminal cases, so that we don't have to burden the people of Guam with conflicts firms again. Already we see it with APD having a lot of conflicts, but that has been reduced substantially, especially from the 90s. Secondly, as far as the maybe I'll reserve the other two concerns on possible litigation on the senior citizens program itself, and and what type of legal advice and representation public defender would give in that program. So that's only my main concern is I want the public defender at least to show me that there will not be a reduction. I mean, there will not be an increase of conflicts based on representation in this program. Maybe I can amend the resolution that, or a report shall be provided with the to the board of trustees on the amount of conflicts that the public defender conflicted out in the 6-month period. But I think that's not really a representation of the conflicts that will happen, because usually conflicts will arise later down the road. So that's my only concern, is that it would raise the number of conflicts that the public defender may have. And I think we have to find a way to control those conflicts. That's all I have to, Mr. Chairman. Thank you very much.
I understand, TJ. Sorry, I was muted there. And if I may suggest, I think the concerns are relevant and can be addressed in the next resolution. At this point, if we just want to allow for us to even go to the second step by lifting the moratorium. I mean, we may not decide to implement it, but at this point, this resolution is to allow us to lift the moratorium so we can consider the second resolution where we can incorporate all the concerns of the board members and limitations regarding the elderly law program, if that would be acceptable to you.
Yes, that would be acceptable to me.
All right. So I'm any further discussion on the motion to adopt resolution 05-20?
Yes, Mr. Chairman, may I be heard?
Yes, Jackie.
With respect to the resolution on the lift, I'm concerned about the paragraph on page 2 about the resolution, the first paragraph. With respect to the limitations and the terms of the LAS program administered by DPHSS. I would propose and amend kind of this particular resolution 6-20 to also restrict the limitation to include compliance with the statutory provisions on limitation of eligibility. My concern is that the LAS program as administered by DPHSS may have different standards as compared to those standards that have been statutorily approved. And that I understand, I've asked that Kathy Gogui have prepared in the event the trustees need it available to review the current rules on eligibility for services with the public defender, because these would be the governing rules on who would be able to obtain services. So at least with respect to the provision on the resolution, I would simply request that we amend that resolution to include compliance with section 11105 of Title 12 before we move to take a vote on the matter.
You want to make a motion?
Sure, Your Honor. I would move, so move.
Can I ask a question? Is that the limitation on indigency, Jackie? Mr. Lahi?
Yes,
Yeah,
that is absolutely, that's correct.
So they don't
That's
represent
correct.
clients that have money that are not qualified as indigent clients.
That would be correct. There is a process that the public defender currently has for intake purposes to determine who is eligible for services. And presumably those are the only rules. I do not have a copy of those rules as of yet. I have asked that they make those available to the Board of Trustees. But if those are the applicable rules that have in fact been adopted by the public defenders, and we adopt this particular 6-month pilot program, I would also recommend that we adopt those particular rules for purposes of determining who would be eligible under this program.
Yeah, again, I think that's relevant in reference to the resolution implementing any program. And that would be the second resolution that Mr. Morrison prepared. However, if you wish to make a motion to modify, you're free to do so in reference to this 05. So you've made the motion. Is there a second to Mr. Lai's motion to modify the resolution 0520 by adding the income level limitations in reference to eligibility to the program?
Okay, that's basically just clarifying the mandate of public defender. So I'll second the motion.
Mhm.
All right, it's been moved and seconded. Any discussion?
Mhm.
There being none, all those in favor, please say aye.
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 Your Honor, this is Attorney Kuby.
Well, let me just
I
make
do
sure
have,
that.
I do have one proposal, aside from what has just been approved by the Board of Trustees with regards to Resolution 06-20. So when, if I could be heard on that after.
You mean 05 or 06, the next
No,
one, right?
06, Your Honor.
Okay.
So first of all, I'm wanting to dispose. So there's been a motion to amend this resolution, and the vote that I called for is on the amendment. And just to clarify for the record, and the amendment is simply to add that any program that the public defender enters into with the Public Health and Social Services, establishing an elderly law program, is subject to the same income limitations that guides or governs the Public Defender Service Corporation. Is that correct, Mr. Lai?
Yes, Mr. Chairman, and if you review your chat box, I have included that particular section.
Okay, so let me just read Jackie's motion to amend. The motion to amend Resolution 6-20, and so we are limited in the terms to the LAS program administered by the Department of Public Health and Social Services and in compliance with Section 11105 of Title 12 Guam Code annotated. So if you could provide this language to Attorney John Morrison, if the resolution passes, to amend this resolution prior to his signature. So, and so, John, you have a copy of this written amendment that was sent via chat to everyone. And so just, if you could just acknowledge that you have received that, John?
I acknowledge, and I've copied it verbatim. Thank you very much.
Okay. All right. So just to be clear again, I'm going to call for the vote on the amendment that was proposed by Mr. Lahi, that was seconded by PJ, as indicated. All those in favor, please say aye on the amendment.
Aye.
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 Okay. So any objection? There being none, so the amendment passes. On the resolution as amended, all those in favor say aye.
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 We need two more votes. Okay.
Aye. Okay. So I just wanted to
Unanimous.
make sure it's been unanimously adopted. Okay. So that resolution has passed. Now, on the resolution 06-20, first of all, I'd like to entertain a motion to adopt resolution 06-20 for discussion purposes.
I so move, Mr. Chairman.
I'll
It's
second,
been
Your Honor.
moved, and it's been seconded by Attorney Ekubi. And so it's been moved and seconded, and now we are in discussion on resolution 06-20. And Attorney Ekubi, you are recognized.
Thank you, Your Honor. I don't have any significant objections to the pilot program resolution. My only concern would be as if we would turn to page 30 of the draft resolution, and on the very top of the resolved, it indicates what the type of work that will be involved in. I'm not opposed to wills, powers of attorneys, and guardianships. However, I am concerned, and I've expressed this already in speaking with public defender as far as doing any kind of deeds that will involve the conveyance of properties or quit claiming any interest in real property. I would feel more comfortable to kind of keep it within the realm of rules, powers of attorney, guardianships, Your Honors, and board, just because I myself do a heavy practice on real estate transactional work and litigation. I see oftentimes that there's really a lot of issues involving that, and it creates there are more costs that are involved in that, and I don't think at this point that with the level or the clientele that that public defender will be assisting, I don't think they'll have that kind of financial resource. And I will identify, for example, ordering title reports, paying for recording fees of these properties, because the recording fees are by statute. So I would ask, and if the Your Honor and the members of the board will entertain, I would move that at least that part of the deeds be at least removed at this time, and we can keep the other parameters of what the scope of work that public defender can do, within the pilot program.
Mr. Kubi, where are you amending the which resolve? Are you amending the resolved or the whereas?
Yes, PJ. It would be under page 30.
Can we? Who's scrolling? Can we
go
see it?
down to page 30?
Can you, JT, if you can go to the next page here.
Yes, right
Yes,
there, Your Honors. It's the very top that will not engage in adversarial litigation for eliminating potential conflicts. The work described by DPHSS, DSC includes wills, powers of attorney, guardianships, and various forms of deeds. I would ask that we consider modifying it to strike the various forms of deeds, specifically because it does involve transfers and conveyances of real property. And I've expressed my concern on that just because my level of practice really involves real estate transactions and a real property litigation. And I just think that with the level of the individuals that PDSC will be representing, I think one, there's just more involved, and two, I think there will be more costs involved. For example, as I pointed out, recording fees, possibly title report fees. And I just think that for this particular pilot program, I think we can really, the public defender can certainly concentrate on the wills and the powers of attorney, guardianships of that. But deeds, I'm just very reluctant, only because that is the basis of my practice. And I've seen a lot of errors and mistakes come from that. So that would be my concern with respect to this particular resolution, Your Honors and board members.
Mr. St. Augustine, do you have any reaction to that? And, Ms. Ekubi, Attorney Ekubi raises a point that if the client has these various properties in reference to conveyances, that there may be issues of eligibility if they have those type of assets.
Right.
Is there any objection to deleting, for purposes of this pilot program, and various forms of deeds? These are related to real estate conveyances, to delete that from the authorized scope of work.
Yeah. Well, the one thing I would ask for consideration is that there is a legal provision that would allow an elder to deed their home to the caretaker or their son, their daughter, their in and out child, but only with the provision that that transaction of the home doesn't take effect until the elder has passed on. And that has helped us in the area of protective services. The deeds, like deeds of gifts, yes, I do agree that it would not be for seniors who have assets. If they have multiple properties, at least in my assessment, they would not be suitable for serving clients in greatest socioeconomic need. It would be for the clients that they have a home, but they want to stay in that home until they pass on. But we want to protect them, because if they give a deed of gift, and they go through another system in which we're not safeguarding their personal interests. We've seen this happen in the area of adult protective services, where a senior would give, it's happened more than once, would give their home to their son, who then gets married and, you know, doesn't get along with the new wife and the mother-in-law. They don't get along. So unfortunately, we've seen a senior be told, basically, Mom, you have to move out. But what has worked is when the elder, be it the mother or the father, provides that this home will go to you, but only when I pass on. If that deed, if that's a deed, of that form of deed, for those who meet the greatest social economic need, could be maintained in the work, that would help those seniors who don't have a large home and just have a modest home, but want to safeguard it. And it helps them also because it has it's that home that they will have until they pass on, and they're not left out in the streets, or they become homeless, or all of a sudden they're in an emergency receiving home because of a situation in the home front. So if that is a deed, and that's a form of deed that we can maintain in our service, that would be helpful for the clients that we serve. And
Your Honors, may I address Mr. San Augustine's comments?
Sure, of course.
Please do.
Okay,
Sorry.
so thank you, Mr. San Augustine, for your comments. And that's exactly the reason why I would like to consider modifying it to remove it, because that's the actual situation I hope to avoid, that in a situation where mom and dad gives it to a child and the child receives the property, then they get kicked out. I think to address your concern, to ensure that mom and dad still stay on the property, that can be addressed in the will. The will is purportedly the last instrument that the court recognizes to ensure that the testator gives the property to whom he or she wishes to have it upon their death. And it would only take effect, the will would only take effect upon their death. And so number one, two things it serves. It addresses the issue that mom and dad are not kicked out because they still own the property. And two, it addresses the concern that it will only occur upon their death when the will is probated before the court. So I think your concern with those who may have a modest home, but they want to avoid, and I think for most of us, we want to ensure that mom or dad or grandma and grandpa are not kicked out, you know, once they do a deed of gift or deeding the property or conveying it to a relative or a child. That would be safeguarded. So that's the reason why I think the will would address your concerns, because then you won't have, if you start looking at dealing with deeds, whether it's a quitclaim deed or deed of gift, then you may be looking at possibly the displacement of our elderly population. And I've seen significant numbers of that happening. So that's the reason why I would ask and have you consider that the will would address that issue. And I'm hoping that the board will also see that. And this pilot program will give us an opportunity to see how things are evolving over the 6-month period. Thank you.
Mr. Chairman, can I address Mr. Kubi's amendment?
Yes.
Mr. Kubi, I sort of agree with you on that because I sit in my courtroom and it does happen. And I'm really concerned about that. I think with that various form of deeds, if you eliminate that, then it still opens the door with powers of attorney. A person get a power of attorney, general power of attorney of the elderly, and then just sign the deeds, giving it to him or her. Doesn't that? So even though we eliminate various forms of deeds, we still have the door open on powers of attorney. So do you want to limit that, a limited power of attorney as far as not concerning land transactions or something? Because you do need a power of attorney for persons to get medication, to do other things.
Sure. And I think there's a way.
But the general power of attorney, but you may have to limit the power of attorney because it makes your various forms of deeds kind of moot. If I have a general power of attorney from my mom, I can basically deed all the properties to myself, right?
Yes.
So
what I would ask
so we have to amend the powers of attorney and make it limited to non-real estate transactions where, you know, I could represent the money, you know, bank, open a bank account for my mom, open, apply for food stamps for my mom, apply for, but I can't sell, all the property that my mom has, right? So,
Right.
we may have to say limited powers of attorney for non-real estate property purposes or something to that effect.
Or non-conveyance of real properties.
Right. So limited powers of attorney, so that basically, we still need the person to, pick up the prescription drugs. We still need the person to apply for food stamps, if they're getting Section 8 housing, to sign on their behalf, et cetera. So we still need a power of attorney, but we have to, it won't solve your situation if the general power of attorney provision is still there. You know what I mean?
Right.
So you may have to amend both.
I'm not opposed to that. I just am more concerned about the fact that, we will be, they will be representing an elderly population, and we also want to ensure that their life and their interests are safeguarded. So I wouldn't be opposed to if the board was amenable to just not in, a general power of attorney, but not to include conveyances or transfers of real estate or real property. I think, again, that could be addressed in the will.
All right, so
one of his,
Jackie, PJ, first of all,
I'm sorry, I'm done. Huh?
Yeah, Jackie has provided us with language that I'd like them to
where's that language?
Read out, so that if the board wishes to modify this resolution. So let's take it a step at a time. So the first amendment to the let me see, 1, 2, 3, 4, 1, 2, 3, 4. The fifth resolve clause on page 30 is to delete and various forms of deeds. So that's the first. Let's take it a step at a time. That's the first amendment to the resolution. And so this is moved by Attorney Ekubi, and PJ, you second that? Is that?
I'll second it, Mr. Chairman.
So I'm going to call for the vote for that first amendment. And so all those in favor of eliminating the text and various forms of deeds, please indicate by saying aye.
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 All right. So it's been adopted. That language has been deleted. So the second amendment is to further limit the type of transaction that can be provided. And it is that the Elderly Justice Center will not participate in real estate matters, including special powers of attorney involving real property deed and other real property conveyances. And so that's the language that is being proposed by President of the Bar, Attorney Jackie Terlahi. And again, this is for just the pilot program, Mr. St. Augustine, and I think big baby steps here. We'll and see how this works out. So there's been a motion to modify this fifth whereas clause, whatever. And so is there a second to that motion?
I'll second that motion, Mr. Chairman.
All right, so it's been moved and seconded, and again, Attorney Morrison has the specific language because it's being sent to all of us. And so it's been moved and seconded, and I'll call for the vote. All those in favor of this second amendment to this resolution as indicated, please say aye.
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 Aye. Okay, so it's been unanimously. Is there any objection? There's no objection, so it's been unanimously adopted. So we have the amendment of Attorney Ekubi and Attorney Terlahi regarding the scope of work. I have a question, and I'd like to direct this to Mr. St. Augustine and to Steve Hattori. And if we look at the second resolve clause, and sorry, I just picked this up as I was reading this further. The second resolve clause, 1, 2, 3, fourth line into this clause, it says, let's pull it up.
Where is that? I can't see it.
It's on page 29 at the second
Okay.
resolve clause.
Okay.
I'm sorry, go up one, JT, go
One
up
more.
further. One more.
That's it.
And that's it. And if you look at it, says here, the Board of Trustees was advised that the EJC will be partially funded by a matching grant between the federal government and the government of Guam. What do we mean by partially funded? I thought that the federal funds would provide the funding for the program that we're entertaining.
Yeah.
So, Art?
Yeah, yes, Chief Justice, yes. Our Legal Assistance Services Program is one of our Title IIIB supportive services. And in receiving federal dollars, when we say partially funded, this is a match requirement. And there is a commitment from the local government of Guam. It's called a maintenance of effort. And we have to maintain the local funding for these funds, these federal funds, to be awarded to Guam. If at any time Guam determines that they will reduce their funding, the grant also has the option to reduce their federal award to us. So there's a required level of funding. It's called a maintenance of effort. So this program is funded by the local government in part with the federal government, which is a matched grant. And so
I see.
We're pulling from two
So
funding
the
sources.
local match, the local match funds, Art, will not come from the Public Defender Service Corporation.
No. Yeah, it comes from Public Health and Social Services.
Okay, so I think we just need to clarify that the EJC will be partially funded by a matching grant between the federal government. Oh, I see, and I guess, and the government of Guam. I just want to clarify that when we say the government of Guam, we don't mean the Public Defender Service Corporation. And how is that funded? Is that through the budget of the Department of Public Health and Social Services, the matching fund?
Yes, it is.
Mr. Sparks?
Yes, it is. Yes,
Okay.
it is, Chief Judge.
Between the federal government and the Department of Public Health and Social Services. I think maybe we need to be a little more specific there.
Okay. And the Department of Public Health and Social Services. Okay.
Yeah. So, John, if you can just specify, and my amendment is to clarify that when we say matching funds, that the public defender is not obligated to match those funds. And that was the whole, that we weren't going to burden the public budget. So is there any objection to that amendment that the matching local funds not come out of the Public Defender Service Corporation's budget?
I move on that amendment, Mr. Chairman.
All right.
I'll second that.
Been moved and seconded. I'll call for the vote. All those in favor of the third amendment to this resolution as indicated, please say aye.
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 Any
Aye.
objection? There being none, it's been unanimous. It's been unanimously adopted. The last, well, an amendment that I also would like to make is that we need to clarify who is it that is the authorized signatories on behalf of the public defender to enter into these agreements and be responsible for making sure that the corporation satisfies the various requirements of this federal program, the federal grant. And I'd like to toss out that we have our administrative director and our executive director be authorized to sign and bind the corporation according to the limitations that we have provided in our board resolution. Before there's a motion made, is there any objection or Mr. Hattori and Kathy Gogui in reference to being authorized signatories to enter on behalf of the public defender with Mr. San Augustine's agency for purposes, if this resolution was to pass, to be the authorized signatories on behalf of the corporation.
I make that motion.
Okay,
This is only for 6 months, right, Mr. Chairman?
that's correct.
Okay, I'll make that motion.
All right, so there is, what again I need, Mr. Morrison, is that we are going to need a resolve clause or language modifying the second to the last resolve clause, wherein the executive director and the administrative director of the Public Defender Service Corporation are authorized to execute any document to implement the establishment of this program. And so it's been moved by the PJ. Is there a second to that motion authorizing?
Second.
All right, so Ms. Janata has seconded. Any discussion on this amendment?
None.
Mr. Atori, is that something that you agree to? You're muted, Steve.
Absolutely, Your Honor. As the director, that's part of our job. So between Kathy and I, we should be able to do that, and we'll run everything through the board as well.
All right. Okay. So there's no objection on the part of our management staff. I will call for the vote. All those
Mr.
in
Chairman?
favor? Yes.
Oh, on the motion? On the motion? Okay.
Yes, on
This
the
is on the
motion. Yes.
motion. Oh, okay. Okay.
Yes, on the motion to adopt the amendment authorizing, specifying who the authorized signatories are to bind the corporation to enter into this program should this resolution pass. So all those in favor, please say aye.
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 Those opposed? It's been, the ayes have it and it's been unanimously adopted. And so unless there are any further amendments, I'm going to call.
I have one more amendment. Mr.
Okay.
Chairman, I just have one more amendment.
Yes.
Basically where Ms. Akubia and Mr. Lai made amendments. I'd just like to, there are two types of guardianships. One is the guardianship of the person and one is the guardianship of the estate. And I think to be consistent with the previous amendments that were done by the two attorneys, I would like to maybe make it specific, make it the guardianship of the person, because if you say the guardianship of the estate, basically that person will handle the entire estate of that individual. So I think it would be inconsistent with the two previous amendments that were made by the two attorneys. So I would amend it to say guardianship of the person, so that they will just be responsible to making sure that the the person is taking the necessary medication, can buy medication on his or her behalf, etc. So I just like it, make it the guardianship of the person.
All right. Okay, I'm just trying to think that through, and if they execute documents providing for guardianship of the person, doesn't that necessarily they have to go to court for that? I mean,
Yeah,
we're not.
But there are two guardianships, one for the estate, which will basically manage their entire portfolio, and guardianship of the person, which basically will just meet the specific health needs of that individual. So if I require to have my prescription drugs fulfilled, or that you want the doctors present, have that guardian present, these things can be done by the guardian.
All right. Okay. So there's a further amendment to limit resolve that Jackie's not keeping up. So I'm just.
Mr. Chairman, may I be heard just briefly on that particular amendment in terms of discussion?
You have experience in this area, Mr. Lai.
Yes, Your Honor. I think that the amendment is a good proffer for our consideration of the types of matters that should be covered by the public defender. And I wanted to kind of give this reassurance, especially to our program coordinator, Director St. Augustine, that there are other efforts like the Office of the Public Guardian that could be utilized for guardianships of the estate. So I don't want Director St. Augustine to think that we're leaving this area unmanned, so to speak, but that there is coverage under our current laws that do cover that type of matter. So a limitation, I think, on guardianships of the person can also be done transactionally via consent first. And if the elderly person consents to a guardianship, then that's the kind of matter that can be filed in the court that allows for them to proceed, of course, with appropriate notice being provided. So I would second the motion if the motion is being considered for at this point.
Yes, the PJ has made the motion to modify that the type of guardianships that's authorized under the scope of work of this program are guardianships of the person and not the estate. And so, and it's been seconded by Attorney Terlahi. And is there any further discussion on this amendment? There being none, I will call for the vote. All those in favor, please say aye.
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 All those opposed? It's been unanimously adopted. All right, so at this time, I'm going to call for a vote of the resolution. What's the number again? 06-20 as amended. And is there a motion to adopt the resolution 06-20 as amended?
Mr. Chairman,
Mr.
Mr.
Go ahead.
Chairman,
Yes.
Yeah.
Yes,
there was one issue that was raised earlier that I'm not sure if it was already covered, if you can correct me. There was a suggestion that as part of our resolution that the EJC be required to keep statistics on conflicts of interest raised during the pilot period. If that was not included in the resolution at this time, I'd ask that that be included.
All right. John, I think you did provide that they were going to keep statistics, if I'm not mistaken.
Mr. Chairman, the list wasn't exhaustive, but it was certainly our intention to be able to respond to the board and to communicate those stats among others.
All right. So Jackie, would that satisfy you that they're going to keep in order for the public defender to make a case in reference to whether or not this program should be continued? I mean, they have to keep statistics and just the type of work that they do, and also the type of work that is restricted now that we may want to consider down the line that should be included.
Yes, Mr. Chairman, respectfully, I know that Mr. Morrison and Mr. Hattori will keep the statistics, but I don't believe the conflicts is required to be tallied under the LAS program. So for purposes of our use, for the Board of Trustees' use and the judiciary's review of the program, I would request that Mr. Morrison and Mr. Hattori just simply do it at the direction of the board. It doesn't need to be part of this resolution.
All right. Okay. And we can make that clear separately. But yes, that would be a part of us reviewing and analyzing the effectiveness of this program and how it affects other parts of the operation of the public defender. So at this time, I am going to call for the vote of resolution number 06-20 and as amended. All those in favor of the motion to adopt resolution number 06-20 as amended, please indicate your support by saying aye.
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 Any opposition? There being none, it's been unanimously adopted. Congratulations, Mr. St. Augustine. It's been a long journey for you and your group and Mr. Hattori. What I'd like to do is that, Mr. Morrison, if you could prepare a update of the resolution with all the amendments. Circulate it, Kathy, if you could circulate it to all the board members to make sure that it catches all the amendments that were made. And if I get an email from all the board members that there are no, that it does include all the changes, then after that time, I will sign the resolution with the recording secretary. That's how we will proceed, and you'll have the opportunity to make sure that all the amendments, and this is being taped, are included in the final resolution. All right, thank you very much, and Mr. San Agustin, I thank you for your patience in continuing to be part of our meeting and to answer our questions. And so with that, we will proceed. And now we're going to, under new business, before we go into executive session, there is one other item that has to do with a car purchase for rental cars. And Mr. Hattori or whoever on the part of the corporation, if you wish to address this matter in terms of what the need is and whether or not there's a funding for it.
Okay,
Thank you, Your
Ms.
Honor.
Cole will address it.
Thank you. Thank you, Your Honor. We have brought to the board 3 years ago the lease of 2 of our cars that we currently use for our investigator as well as process server. Our lease agreement is up, and we either turn the cars in and go back for another lease, or we purchase the cars. What we would like to recommend is that we purchase the 2 cars that we have. I've provided the amounts that we are asking for the 2 cars that we do have. We looked at the Blue Book value, Kelly Blue Book, for both cars. They're still in excellent shape and condition. We've not had no problems. There's very little usage on the car. So the Kelly Blue Book, and this is not excellent, so I went good. The Kelly Blue Book value for both these cars is $15,000. It ranges anywhere between $50,288 and $16,791. What we are asking for the cars, JT, where's the? It's a little toward the end. So what we're asking for the cars is, JT's going to pull that out right now. In the amount, I think I have it here. It is for $12,000 is our buyout, and we are going to use lapsed funds. So we will ask for $24,000 to purchase both cars that we use right now, so that we no longer do the lease. In the 3 years that we use the car in our lease agreement, and this is just for one car, it was $20,520. And so if we continue to lease the car, and I'm just talking about one, but you multiply that by 2, it costs us $6,840 a year for lease of these cars. And when we went out for the lease agreement with these 2 cars, we did put it out and we did get quotes, and we have that on file. We went to the dealerships and we gave a deadline. Whoever provided us with the response is what we used for comparatives.
All right, there is a request on the part of management to purchase these 2 vehicles that have been leased for the last, I assume, 3 years.
Mm-hmm.
Yeah. And it's for $12,000 each, and the source of funds is from
lapse funds.
Sorry, from lapse funds. Prior year lapse funds. Is there any questions before we have a motion to adopt authorizing management to make these purchases? All right, is there a motion to authorize management to purchase the 2 2017 Hyundai Tucson SUV as indicated in the Hyundai quotation that is dated July 24th, 2020?
Mr. Chairman, if I may be heard briefly, I'd like to ask one question about the viability of purchase versus continuing with the lease of other vehicles. Have we explored that? And in terms of the monthly payment that would be required for newer vehicles, with the lease option as opposed to purchase at this time? Have we done that analysis?
We have done the analysis. If we continued with the lease, we'll be spending close to $6,840. So you're hovering, when we went out in 2017 for the lease, Cars Plus was the lowest of the, we've gotten them from the big dealerships. They were the lowest to provide us with the quote. And so if we get newer cars, I mean, these cars are basically in mint condition. And like I said, when I went to Kelly Blue, I went for good, not excellent. They've got low miles. We only use it for runs or for investigations. So we don't use the cars for any other purposes, but for what we need with our investigations and our process server. So I think that if we bought the cars, it would be greater value to the organization. They have another good life of about maybe 3 to 5 years, even longer. I have had cars that have been 20 years old. So, and have kept my cars for that long. So I hope that we still take good care of the cars. And I would highly recommend we purchase over the lease option.
Okay, okay.
Mhm.
That
All right,
answers my question.
All right, thank you. Thank you, Jackie. Is there a motion to authorize management to purchase these
Motion.
vehicles as? All right, it's been moved by Trustee Kanata. Is there
I'll
a second?
second it, Your Honor. I'll second it, Your Honor.
It's been seconded by Attorney Ekubi. Any discussion? There being none, all those in favor, please say aye.
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 Okay, any objection? There being none, the motion is unanimously adopted. All right, so we are now going to recess, and well, before we do so, let's go into the next part of our agenda is the executive session.
Mhm.
And so at this point, JT is going to put the board members and Kathy Gogui and Catherine Sablon in another room so we can have a private discussion on these personnel matters and any action. Then we'll come back to the public portion of the meeting should there be any vote on these performance evaluations. So JT, are you set to put us into a?
I'm working on it right now, Your Honor. So, so we'll be done. I have you and Donna moved over. So, Your Honor, I have to put them all together in one room, right?
Yeah. We're all
Yes, that's correct.
Can I be excused for like 3 minutes, please?
Sure.
Yeah, the next time you will be hopefully in a virtual room, another room, but yes.
Options.
See, I'm not seeing my option where I can do it.
Yeah.
I don't know if a co-host can do it. I thought we could.
Yeah. We're getting Steve Torrey. He's, I guess, familiar of doing this. Because I can see a sign, but when I do, oh, maybe I can go, okay, here we go. Got it. So QB.
Mhm.
And who else? Presiding judge.
And
Jackie.
GBA president.
Okay. Okay, QB, Donna, GBA president, and Kathy Gogui.
Yeah. Just, it would be this one, huh? So JC, it'd be this
Oh,
room,
it would just
the
be-
boardroom. I think we got it. It'd be the boardroom. Wherever you're, whatever this is.
Oh, public defender?
Yeah.
I think automatically it's in there.
Because you're creating.
I'm creating it. 1, 2, 3, 4, 5, right?
Mhm.
And that's it?
That's it.
Right.
So you open that room up.
And where's it open? So open all rooms?
No,
No.
so we're gonna have to delete those other rooms.
Huh?
You're gonna have to delete those other breakout rooms.
Okay, delete, yes. Delete, yes. Delete, yes.
And breakout,
Okay.
yeah.
Yes. Yes. Okay, I'm gonna open up the room. Okay.
So we're there now, right?
Okay,
Just,
so Your Honor, that,
So
We
you
have a
join,
breakout.
there you go.
Yeah.
Now you join.
so join,
So that me and Kat can.
okay.
Yes.
Yes, please.
They're trying to put people in, oh, there, they got it. In the breakout room.
We're the only ones left here? Hey, is this thing still recording and playing on YouTube or?
Should act like it is.
Ay, leche. Okay.
Can you read that or is that backwards, Annie? Oh, you can read it? Oh.
Congratulations, Steve.
It just means more work now. But I think once you get the program up and running, it'll run itself. And now we have to, and we can do less work now.
Is this all being recorded?
So did they want us to stick around, or what did they say? Huh?
Was that for everybody?
To adjourn, right?
Yeah, they're going to go in executive session. They'll come back out to vote on anything relating to performance evaluations, and then they'll adjourn after that.
Did they say anything about wanting to interview us, or like stick around in case we need to interview you?
They didn't mention it, but I'd proceed as though they expect us to be here when they come back in session.
Okay, thanks. Just really glad that the board decided to, support this. It's going to be a great program for Guam.
Well, if this goes past 8, then I'm sure I was wrong, and you should probably just go home.
Okay. We should be back now.
Yes, we are, JT, and I want to commend our IT specialist, Mr. JT, for his expert handling of us back. And we are again live.
Of course.
And I just let me just pull up the agenda here, JT.
Okay.
We are now back in under old business performance evaluation. The Board of Trustees have risen from executive session, and we're now back under our regular board meeting under old business, the performance evaluation. And I just want to announce that the board was not able to act on the performance evaluations. They wanted further information from management in reference to a report from the managing attorney, similar to the last report she did in 2017 regarding the certain actions that she had taken in reference to the office. The single sheet performance evaluation that was provided to the Board of Trustees is more for a employee evaluation rather than someone who's in a management level in reference to supervising an office. And so, Annie, we're going to need a report. I understand that you've submitted a report, I'm sorry, to Catherine Sablon, and she's going to circulate that, and the board will determine if that's sufficient to complete the evaluation. You'll please be assured that the evaluation will be completed by the next board meeting. Should there be a satisfactory performance per the attorney pay scale, the payment would be retroactive to October 1st, 2019 going forward. And as far as the executive director, they're also wanting a similar report in reference to the certain additional elements that were asked in the January 2020 Board of Trustees meeting, and what steps were taken to address those concerns. And also, there will be a final resolution of this matter at the next board meeting. So the action on the performance evaluations have been deferred for 1 month until the next board meeting to give all the new board members the time to absorb all the reports and be informed in before making a decision in this matter. Do you have any questions that you, first, Attorney Gale, do you have any questions of the board's action?
I guess my question is, do you want me to prepare a different report for the board to review?
Jackie, did you, or who's the one that, or maybe QB, or someone asked if that there be additional information that's provided?
I'll answer that question.
Go ahead, PJ.
I'm sorry.
No, go ahead, Attorney Kubi, you go first.
I believe that Ms. Gale already submitted a report, and I think the rest of the board just needs to review it. And I believe I think it's that some of the board members still need time to take a look at that. That's my understanding. So I don't think we requested a new report. I think something was already prepared that the remaining board members just need to review it. If that's my understanding.
Catherine, is that what was submitted to you on Friday that prompted this discussion?
So it was a review of goals from 2017 evaluation and future goals. This was dated December 17, 2019.
I submitted that to the last board, and I submitted that to Ms. Sablon to disseminate to the board members. But I could, that's, if you need.
You don't
me
have to do anything, Annie. It just needs to be sent to all of us. And
Yeah.
so it'll be sent to all of us, and we'll review it. If we have any questions, we can contact you directly, or through, we'll contact you directly. And Steve, do you have any questions of the board? You're muted, Steve.
I'm trying this space bar. It works like a walkie-talkie. Anyways, I did submit 2020 list of goals. There might be things I might need to add, so I'll submit that in advance of the next board meeting. Are we going to also be able to address the board itself at the next board meeting?
I don't think it's necessary. I think we just need to make a decision. We just want to have the basis of a written report, and so our decision can be properly documented, and unless any board member feels otherwise. Do you want input from our two management employees?
Mr. Chair,
I don't think so. Yes, go ahead, Jackie.
I agree with you. I don't believe it's necessary, but I do believe that Mr. Hattori, there was a report that either you generated or we had requested that you generate in January of 2020. So if you could take a look at the notes and see what we requested and provide us a report in advance of the next meeting to address those concerns. So the date of that particular, I believe, was January 14th. Okay, so I don't know if you have already issued the report. If you've already done it, obviously, it just has to be transmitted, but I don't recall seeing a report, that's all.
And I think when the board came out, is that the report that they generated after voting on it at that board meeting?
We've requested that you provide us a status on certain issues as a result of that meeting, yes.
Okay,
that's correct.
We'll look at that. It's just that because we try to go over that executive board meeting, and most of it wasn't actually recorded. So I'll prepare the report as to the best of my ability. But if there's anything specific you want, just let us know. We're here for you guys.
Okay. All right. Thank you, Mr. Hattori. PJ, any concluding remarks?
I don't have any, Mr. Chairman.
All right. So at this time, I will, anything on public discussion? Does anyone have
Can I
any?
just, okay, Annie.
First of all, I will recognize our executive assistant. Kathy, whatever your title is, go ahead.
Administrative. Okay,
assistant.
whatever I have.
Executive Director.
Yeah. We have our
I know
board.
you're important. All I'm going to say is I know you're
We
important.
have,
I'm
yeah,
recommending you.
thank you. We have our budget hearing that was rescheduled from last week Thursday to this Thursday. That's at 9 o'clock this Thursday, and we'll go on first, and then we have APD following.
All right, and they're only allowing two at a time, so
Correct.
I will be watching, and I'm hoping that you're able to persuade our good chairman of the Appropriations Committee to fully support the budget requests that we transmitted.
Thank you.
Ms. Gale, you had your hands raised?
I was just gonna tell you about the legislative session on Thursday. That's all.
Okay.
And
Thank you.
can I say something?
Yes, Mr. Hattori, your public
thank you.
discussion.
Okay, first, I would really like to thank each of the board members for keeping an open mind and, having faith in our office as we try to address your concerns that you all raised. And I hope we satisfied your concerns. We hope that in the next 6 months, we'll be able to establish that this program can and will work for the Monomco as well as for our office. I mean, we both share the same concerns. I mean, ask anybody here, my pet peeve is conflicts. We've been working hard to reduce our conflicts, and we believe that the resolution that you passed, creating that conflict wall, should address the concerns. We have no intention of allowing our civil work to impair our ability to represent our clients in very well in our criminal realm. But I really appreciate each of the trustees for the time you took. It's been a very long process, and there was a lot of work that went into it, and we really appreciate you having faith in us, and the team is really appreciative, and really we're not going to let you down. We'll make you guys proud of this program. Thank you.
Thank you, Stephen. I also like to acknowledge Attorney John Morrison. His research went a long way to addressing the concerns of the board members. And John, I want to thank you for your professionalism and the diligence and the quality of the work that you put forward. And I think that's going to help in terms of establishing the program and hopefully moving it forward. Anything else? There being no further comments, at this time, I will, John, I'm sorry, I didn't mean to cut you off. Go ahead.
That's all right. It's part of the technology. I just wanted to say thank you very much for those sentiments, Chief Justice. And some of the research was a group effort on the office's part, and we had a terrific legal intern that was able to assist us in some of that heavy lifting. I also wanted to advise the trustees that we are currently revising the resolutions, and you should check your inboxes. They should be available later today. Thank you very much.
All right. Thank you, John. At this time, I will entertain a motion to adjourn.
Move to adjourn, Mr. Chairman.
I'll second.
Seconded.
It's been moved by the PJ and this time seconded by Ms. Munya Kanata. And so all those in favor say aye.
Aye.
No objection. This meeting is adjourned, and I very much appreciate and thank you all.
Okay, adios,
Thank you,
everybody.
CJ. Thank you, PJ and all.
Safe.
Yep.